Well, not only, again, was this the first time Mr. Grez failed to appear for a hearing,
My client simply tells me she didn't get the notice of the hearing.
there is also a felony parental kidnapping charge. She took off with a minor child and fled. She was finally found and arrested.
Your Honor, I would disagree with that classification. My client did not flee.
Thank you. This is set for hearing today. Number one, we have this set for a status conference. Number two, Ms. DeGrasse, through her counsel, has filed an objection to an order that was entered by the referee back on July 1st. We've had a chance to review that objection along with Mr. Blumberg's response to that objection. And so typically, Mr. Breicher, what the court would do at this hearing, although I think we've got some threshold issues that we're going to need to address, would be to, I kind of treat these as a pretrial type hearing because this is my motion day, so I don't have evidentiary hearing scheduled for this date, but the court would set it for an evidentiary hearing at a later date with input from both sides as to the amount of time that we would need and how many witnesses and so forth. But my understanding based on your response, Mr. Blumberg, is that it's your position that the court should not even allow a de novo hearing based on Ms. DeGrasse's failure to appear at the referee hearing. Is that a fair statement of your side?
Yes, it is, Judge.
Is there anything you wanted to say in support of that today?
Well, not only, again, was this the first time Mr. Grez failed to appear for a hearing, she had filed an earlier objection on another referee ruling. We had a hearing scheduled before, Your Honor. She failed to appear for that. She's been held in contempt now, I believe, 3 times. Referee legal recommended and imposed 3 days of jail for continued denial of parenting time. And I think the front of the court documents clearly establish right in the second page that failure to appear for a referee hearing, one loses their ability to file an objection. So I think given that history, the denial of this objection would be appropriate.
All right, Mr. DeBreaker, what's your position on that?
Well, Your Honor, first of all, my client simply tells me she didn't get the notice of the hearing. Your Honor, we filed specific objections and requested the de novo judicial hearing, and although that right does exist regardless of whether she appeared before the referee on that hearing, like I said, she simply says that she didn't get the notice and therefore had no opportunity to testify, cross-examine, all those good things. And following what appears to be an hour of testimony from defendant alone, the recommendation, which has interim effect, completely altered the ECC, including the sole legal and primary physical custody aspects of this case. It permitted relocation, substantially reduced my client's time, and of course imposed a three-day jail sentence. We acknowledge, any prior contempt history does not eliminate her right to have present allegations heard by the court, nor should incarceration be enforced before the court can, I suppose, independently review the contempt issue at the de novo hearing. My client is prepared to present evidence regarding the established custodial environment, domestic violence and safety allegations, and ultimately, Your Honor, this is not a simple parenting time motion. This is a complete change in custody and parenting time where my client has all the parenting time. Now she's, I think, limited to about 3 weeks, other than holiday time. So, Your Honor, I mean, my client does acknowledge that my client acknowledges that was a very important hearing, and she acknowledges that she would have liked to be present. However, she just states that she simply didn't get the notice.
All right, I have a couple questions. What's the status of the custody of the child now? Because that's not clear to me based on the filings.
Judge,
Your Honor,
I'm sorry, who are you directing that to?
Sorry, I should have said that, Mr. Blumberg.
Judge, based on the referee's ruling, custody has been physically changed to my client. There is also a felony parental kidnapping charge against Mr. Grez that's pending. When the law enforcement went to enforce referee legal's, in fact, your order, she took off with a minor child and fled. She was finally found and arrested. So physical custody resides with my client.
Your Honor, I would disagree with that classification. My client did not flee simply because she wasn't home at the time the order was supposed to be enforced. But Dad does have the child.
Where is are you saying charges have been authorized, Mr. Blumberg, and in what jurisdiction? Here in Otsego County or somewhere else?
I think it's Otsego, but it may well be Oscoda County, as Mr. Grez was residing in Oscoda County. But as I give more thought to it, I think it's out of Otsego County.
You're right. I do believe it's Oscoda, if I'm not mistaken.
Okay. Mr. DeBreaker, has your client been arraigned on those charges yet?
I believe she has. She is released on bond currently.
Are there any bond conditions that deal with her ability to have contact with the child?
Your Honor, I believe she just was released on Friday. I don't have that information regarding bond conditions currently.
Well, I mean, I guess I'm going to assume in a case where that's the charge, there's going to be a bond condition prohibiting your client from having contact, I would think. Okay. I'm going to ask counsel to just remain here connected for a minute. I just want to see if I can get some more information on the bond conditions from either Oscoda or Otsego County. I'm not going to take a lot of time because I do have to go forward with the docket. But if everyone could just remain on the line, I'm going to put you all back in the waiting room, and it'll just be a couple minutes. Okay, we're back on the record in file number 2419634. I don't think the case is in Otsego County. We tried to find a record in Otsego County District Court, and at least in the short time I had to look, I couldn't find that. So I believe it's in Oscoda County most likely, but so I'm not able to see what the bond conditions are. But either way, to address some of the issues that have been raised here by the parties. Number one, I took a close look at the file and the orders that have been issued over the past month or so since July. And it appears, as well as the file in general, and kind of what's gone on over the past 6 months or so in this case. And so there's a couple of things that I think are noteworthy in terms of the court's determination about how to proceed. Number one, I think there were two issues raised at the July hearing, and that one was a motion to change custody, and the other was a parenting time violation. And when I read the referee's recommendation with regard to custody and the referee's findings with regard to parenting time violations and contempt, which the custody part of it, the court did not sign an order adopting the custody part, but did sign an order dated July 2nd adopting the findings regarding the parenting time violation. And so the language regarding interim effect, in my view, and my reading by the referee, all refer to the penalties, for lack of a better term, for the parenting time violations. In other words, that the defendant would get custody for the remainder of the summer as a make-up parenting time thing, and that was given interim effect. There isn't any language in the recommended order by the referee giving interim effect to the change of custody. I don't know that as we go forward here that's a difference that, or a distinction that makes a difference, but I think it's important to point that out. So, you know, when the court looks at Mr. Grez's objection based on the interim effect, number one, looking at MCR 3.215 G3, which was cited, does indicate that the court can't give interim effect to changes in custody by administrative order. In other words, the court can't issue a blanket order that any of those things are just automatically given interim effect. It doesn't say that the court can't, on a case-by-case basis, give interim effect to changes in custody. So to the extent that the remedy for the parenting time violation, in other words, giving the defendant parenting time for the remainder of the summer of 2026, to the extent that that does result in a change of custody, the court finds that there isn't any violation of the court rule or anything that would prohibit that from having interim effect, because it's not resulting from a blanket administrative order by the court, but rather individualized finding, in this case, based on the referee's recommendation and findings, that was an appropriate remedy. So the court finds that there isn't anything procedurally improper about giving interim effect to that portion of the order as objected to. So I'm denying that objection for purposes of the record. Then the issue is the defendant's argument regarding whether or not the plaintiff is entitled to a de novo hearing at all. I appreciate Mr. DeBrey, yours and your client's position that she didn't receive notice. The file reflects that she was provided notice at her last known address. If she has not updated that with friend of the court or with the court clerk, then that's something that's, on her end. The objection references some kind of health issue along with not receiving notice. So I don't have any documentation supporting that there was some kind of health issue that would have prevented her from attending that hearing. I also think that, to me, suggests that, when you have two kind of excuses for not making a hearing that are mutually exclusive. In other words, she either didn't know about it or she couldn't attend because she had a health issue. It can't be kind of both of those at the same time, or, it's hard to argue those two things as alternate theories for her failure to appear. So I find that troubling. I'm not sure that I find Ms. DeGra's failure to appear for that hearing to be for a good cause based on either a health condition, which I have no documentation of, or that she didn't receive notice when there's no indication in the court file that her notice was returned to the court as undeliverable or something like that. And, kind of making those two excuses at the same time, to me, undermines the credibility of any excusable failure to appear for that hearing. I also have to take note of what's gone on prior to that, which is multiple failures by Ms. DeGrasse to appear. She filed an objection to a previous order by the referee. The court set that for hearing on February 2nd of 2026. She failed to appear for that hearing. The court reset it for March 2nd of 2026. She failed to appear for that hearing. And those were, again, not things that the court was ordering her to appear for. Those were dates the court set at her request. It appears to me that there was a hearing set in front of the referee or held in front of the referee on May 27th of 2026, where the scheduling was set for the July 1st hearing. The referee's order there seems to indicate she didn't appear for that hearing either. So it just refers to the defendant and the defendant's attorney appearing for that. Also, there were requirements put in place, not only that she appear for the July 1st hearing, but to exchange witness lists and comply with other procedural requirements, which the defendant did. And along with not appearing for that hearing, the plaintiff did not either. So I guess if she didn't have notice, I guess that would excuse that. But if it was based on a health issue, there's no reason why she couldn't have or wouldn't have submitted those kind of things prior to the hearing in preparation for that hearing. And then if she couldn't attend because of some last minute health emergency, again, those things just it's not all adding up. And all of that on top of the fact that the purpose of a de novo hearing and the right to a de novo hearing is where both sides appear, they present evidence in front of the referee. The referee makes factual findings, and one side or the other doesn't agree with those findings and wants a judge to make a determination based on that. I don't think in a circumstance like we have here, where the defendant has appeared all along for every hearing, was ready to go with witnesses, had supplied witness and exhibit lists in advance of that hearing on July 1st, was there ready to present evidence and did present evidence. And where the plaintiff has a history of non-appearing for hearings, doesn't appear for that hearing, and essentially allows the plaintiff to skip the entire referee process, to me is not the purpose of the right to de novo hearing. And so if this was a situation where that was the only hearing that the plaintiff missed and she had otherwise complied, I think there would be room for a finding of good cause, and either to refer it back to the referee for a hearing or to have a de novo hearing in front of the court. But again, this is more than just that. I think there are multiple factors here. And then that's to say nothing of Ms. DeGra's failure to comply with the court orders and to be currently charged with parental kidnapping on top of all of those other things. So all of that taken together, again, the court provides a basis for the court to find that she's waived any right at this point. I simply think it would be unfair to allow her to engage in this entire course of conduct going back to February of this year of not appearing, of not seeking to address her own rights in this case, and then at the very end, after the defendant has complied with everything, now seeking for another hearing. So again, based on the entire course and sequence of events, including what's happened since that July recommended order was put in place, the court is going to deny the objection in its entirety. And Mr. Blumberg, I would request that you submit an order to the court reflecting that ruling. And Mr. DeBreicher, to the extent that, you know, I guess I would just say it'd be up to you from that point forward to address any other legal procedural rights Ms. DeGrasse may have to challenge the finding of the court here today.
Understood.
So, the court's not going to order any further proceedings. The order from July 1st of the referee will be given effect. The court will, Mr. Blumberg, if you can include in your order a statement indicating that the friend of the court should draft an order for the court to sign.
I can do that. I just want to make sure we're all on the same page. If the objection has been denied, that means that the referee's recommendation becomes the order of the court?
Correct.
Okay. And again, I don't mean to, I guess I just want a little clarification. Given that the referee took testimony and made a recommendation that custody should be changed, does that mean that at the end of the summer, the defendant continues to have physical custody of the child?
Right. So that order will go into effect because the court is denying the objection to all portions of the referee's findings from July 1st.
I understand. Thank you.
Okay. Thank you. That's all for this hearing today, and all parties are free to disconnect at this time.
Thank you.